Hello and welcome back to our series exploring different US state privacy laws. Today we're focusing on the Maryland Online Data Privacy Act, or MODPA. Maryland is adding its voice to the growing list of states setting comprehensive privacy requirements, and it stands out for how it handles sensitive data specifically and also algorithmic decision making. MODPA introduces obligations that go further than many existing state laws. It creates new compliance and operational challenges. So let's start with its scope. The MODPA applies to organisations that process the personal data of at least 35,000 consumers in a year, excluding payment transaction data. It also applies to those that earn revenue from selling the personal data of at least 10,000 consumers when sales account for 20% or more of its gross revenue. Now, unlike other states, Maryland does not provide sweeping exemptions for nonprofits. So the only nonprofits excluded are first responders or those processing personal data solely to assist law enforcement in investigating crimes or fraudulent activity relating to insurance. That narrow carve-out means that many nonprofit organisations will need to comply. The MODPA uses the term personal data rather than personal information, and it defines sale broadly to cover exchanges for monetary or other valuable consideration. MODPA sets a high bar for sensitive data. It defines this category to include genetic, biometric, health, precise geolocation, and children's data. Collecting, processing, or sharing this type of information is only permitted when it's strictly necessary to provide or maintain a product or service that the consumer has requested. On top of that, the law prohibits the sale of sensitive data outright. So consent for this does not override the prohibition, which is a major shift compared to other state laws. The law also grants consumers a full suite of rights. So these include the ability to be informed, confirm processing, access, correct, and delete personal data, with exemptions where legal retention applies. Consumers have the right to data portability and the right to opt out of sales, targeted advertising, and profiling as well. For profiling, the MODPA makes an important distinction. So the right applies to decisions made solely by automated means that have legal or similarly significant effects, such as lending or hiring decisions. And consumers also can ask for the categories of third parties that receive their data, and they may wish to designate a representative to exercise their rights on behalf of them. Now, consent plays a central role in the MODPA, and any further processing of data beyond the original purpose, as well as any handling of sensitive data, requires opt-in consent. Organisations must also provide a straightforward way for consumers to withdraw that consent, and they must honour it within 30 days. Sensitive data is subject to stringent requirements under MODPA. Controllers may not collect, process, or share sensitive data concerning a consumer, except in cases where the collection or processing is strictly necessary to provide or maintain a specific product or service that has actually been requested by the consumer. And as I mentioned before, controllers may not sell sensitive data even with consent. Turning to obligations, controllers are expected to maintain reasonable security measures, conduct risk assessments, and provide clear privacy notices about their data sharing practices. Data protection assessments apply to processing activities that occur on or after October 1st, 2025. Regarding the sale of personal data to third parties for targeted advertising or profiling, controllers must clearly and conspicuously disclose such sale or processing, as well as the manner in which the consumer may exercise their rights to opt out. Disclosures must be prominently displayed and use clear, easy to understand, and unambiguous language to state whether consumers' personal data will actually be sold or shared with a third party. Third parties that use or share consumers' personal information in a manner inconsistent with the promises made to the consumer at the time of collection must provide the consumer with notice of the new or changed practice before implementing it. This notice must be provided in a manner and at the time reasonably calculated to allow the consumer to exercise their rights provided for under MODPA. A unique requirement in the MODPA is the need to address algorithms used in processing activities in data protection assessments. This underscores the state's focus on automated decision-making, and processors will also have obligations in this respect. They must follow security requirements, stop processing when directed by controllers, and help with compliance and rights requests. Enforcement sits with the Maryland Attorney General, and organisations will have 60 days to fix issues after receiving notice, which is longer than some states. But the penalties will reach up to $10,000 for a first violation and then up to $25,000 for each subsequent one. Now, importantly, there is no private right of action for consumers, meaning individuals cannot bring lawsuits directly under the MODPA themselves. And while the MODPA becomes enforceable from October 1st, 2025, it is important to note that it will not affect or apply to processing activities that occur before April 1st, 2026. So this gives organisations a narrow window to operationalise requirements, but should also not cause any delay in preparation. So what are the key updates and notable changes for 2025? The requirements for sensitive data are stricter than in many states, so that's something to bear in mind. And the law's focus on algorithms when conducting data protection assessments is new in the US privacy space. While consumers' rights and control obligations align with broader state trends, Maryland does diverge in its definitions of sale and its limited non-profit exemptions as well. So here are 3 steps organisations can take to prepare. First, inventory the data, so paying very close attention to how sensitive data in particular is being handled. Second, assess high-risk areas, particularly any use of algorithms and practices involving sensitive data. And third, work with privacy, legal and security leaders to update any notices, consent mechanisms and risk assessment procedures. By acting early, organisations can adapt into policies and processes already in place to build a defensible approach to compliance. And if you need help to operationalise these laws, please talk to one of our compliance experts today.